Hello, sir.
Hello. Yes. Hello.
Yeah, are you audible to me?
Yes, yeah, I'm yes. Sir.
Yes,
Am
sir.
I?
Are you audible to me?
Yeah. Am I audible?
Yes. Yes, sir. You're audible.
Okay.
So we'll start the webinar.
Hmm.
Good morning, one and all. Welcome to all to the continuous series of the real estate webinar. Today we are going to discuss disputed issues and constitutional challenges by Shailesh, sir. Shailesh, sir, you can take over the session.
Yeah. Can you just adjust the video because I am unable to?
Let me
Yeah,
check, sir.
I'm not able to see my. Yesterday's was.
Sure,
Yes, sir.
sir.
Please again start your video, sir.
Okay.
Sir, I am just stopping your video and okay. Yes, sir. Please.
Hello.
Yes, sir. Sir, can you please start your video? Okay.
Yeah. Start. I have started it.
Sir, it's showing black screen at present.
Yeah, because on my screen I'm unable to see. As yesterday I was able to see myself.
Yes, sir. Now it's visible, sir.
But I don't know why I'm not able to see my face.
Never done. But your
on the side in the box.
सर प्लीज आपकी जो चेयर है सर थोड़ी सी पीछे रहेगी तो ज्यादा बेटर फेस क्लियर देगी या सर इट्स परफेक्ट
But why am I not able to see my face on the video?
I need to check it, sir. Let me check. Yes, sir. Can we start, sir?
Yeah, we can start, but I don't know. I mean, in the box, I am unable to see my face. I was just wondering why.
Actually, there is a some option there, sir. You need to check it.
So which is the option?
Like a full screen.
No, that is switch camera, stop video, share content.
Hey, on the right side, sir. On the upper box.
Right side only. Stop meeting, minimize meeting, raise hand and disconnect audio, chat. There is no other option available to me. Anyway, let us start. You are able to see me, right?
Yeah. Yes, sir.
Okay, I'll just carry on. It would have been better if I was able to see myself. Anyway, good morning, friends. We will take it off from when we left yesterday. Yesterday, I tried to give you a complete background of how the overall policy of indirect taxation has evolved over a period of time, pre-service tax days, during the VAT regime, post-service tax days, post-negative list, and now under GST. Particularly the concept of works contract, which is at the core, which is at the root of this entire taxation of the real estate sector, was gone into detail by me. A few of the participants, or maybe almost all participants, might have felt that I went too much into the detail. But believe me, right now, in every single issue concerning the real estate sector, in the context of levy of service tax or levy of GST, which we are grappling with, and I am sure many of you are also facing those issues. All these, the past history, the landmark judgments which have been actually announced by the Supreme Court mainly from time to time, be it K. Raheja, MCHI, BSNL, Gannon Dunkerley, second Gannon Dunkerley, L&T, all these judgments and the ratio of the principal laid down therein have been actually as much relevant as today when you are actually trying to analyze the current provisions. That is the sole reason why I decided to go into the detail, and it was sort of I was trying seriously to lay down a foundation which would, from where we can take it, all the issues which are arising in the present context also. Today, my entire, the coming about 2 hours will be entirely devoted only to the issues only. And those issues we will try to analyze in the context of the legal dispute. I do not intend to go into any technicalities like the computation formula running into some 100 pages of the 42 and 43. All those aspects we are not concerned with. That is not the subject matter of the today's topic also. I'm mainly going into the major broader aspects, broader legal issues which are arising. From that perspective, the issues have been actually framed by me. And particularly in the context of joint development agreement, as yesterday I mentioned, there are 7 case studies which were recently discussed in a panel discussion where I was the panelist, organized by Hyderabad CTC and other co-bodies. And from IT perspective, there was another learned speaker from Hyderabad. So those case studies basically cover almost all the issues concerning the JDA, which I would be taking up. So for the benefit, I have taken up those case studies as a separately for JDA also. And obviously there are other issues. Just to do the recap of the yesterday, what we have actually discussed. I was on the constitutional validity of notification 3/2019 city rate. If you very carefully see that 11/2017 city notification, the parent notification has also been issued under section 9(1)(3)(4), 11(1), 15(5), and 16(1). The subsequent amendments made to that notification, particularly where the amendments relate to the real estate sector, which is at serial number 3 of the notification, mainly 11/2017, those notifications have also been issued simultaneously by invoking all these provisions: section 9 charging provision, 11 power to grant exemption, section 15 valuation, section 16 ITC related. This is quite baffling because, as I said, 9(1) is basically a charging provision whereby by notification a tariff rate can be fixed not more than 28% not more than 20% under CGST by the central government on the recommendation of the council. Now, this section does not permit central government to prescribe any conditions while prescribing any rate, which we call it as a tariff rate. They do not prescribe it. So therefore, 9(1), whereas 11(1) is basically an exemption notification power, which can be also prescribed by way of which can be without condition or with condition. It can be partial exemption, it can be whole exemption. 15(5) has no relevance at all as far as all this mechanism is concerned. Section 16(1) has also no relevance whatsoever. And the word used prescribed in both these provision means prescribed by rules. Therefore, notification, a subordinate legislation, another form of subordinate legislation, by notification, the central government cannot prescribe any conditions. That is my humble view. And therefore, the validity, constitutional validity of this entire notification, I am afraid even of 11/2017 can be under serious dispute. Does that mean that we read section 9 only where there is no condition? There are many entries in 11/2017 where the rate has been prescribed without any condition. If that is so, and if we read it that way to give the benefit of doubt, that yes, I will read section 9 as an authoritative source only for that entry where there is no condition in the notification, then entire new real estate related entries are riddled with the conditions. When they are riddled with the condition, only section 11 will be relevant. And section 11 explanation says, there is at the end of the section 11, there is an explanation which says that if there is an absolute exemption, wholly or partly, that cannot be foregone. So if I read all the new entries inserted in serial number 3 by notification 3 by 2019, even if they were held to be only under section 11, and even giving the benefit of doubt, as I say, then it is a conditional notification, and therefore the attempt to actually make it a mandatory by saying that yes, there is no option now left with the real estate sector to pay the tax at any other rate and then take the ITC, I think that falls flat against the explanation. That will not be the correct contention to say. So coming to the entry, residual entry. Next slide, please. Coming to the next, residual entry. Go to another slide. Next slide. The residual entry 12 speaks about construction service, and that construction service other than the previous entries, and where there is a 18% rate is prescribed. In my humble opinion, this residual entry can very well be availed, can be very well be resorted to by the builder developer, where under the tax liability at the full applicable rate can be discharged, claiming the full deduction of the value of the land, not 1/3 even, because that would not be, because this is a works contract that can be done, and the tax can be paid by availing the full ITC. That is my view. Next. Right. This is what I have covered. Next. In the same breath, this omission of entry on works contract, as yesterday we were discussing, just to say that this omission, whether it is intentional or whether it is the unintentional, that's a different matter to say. I will only say that this omission in a way cannot make the builder liable to pay on the full value of land in case of affordable residential apartment, and nor can it be sufficient to hold that now there is no option but to go for the 1% or 5% and with the deduction of the 1/3 value of the land. Residual entry 12. Interestingly, please note that, and this is very important, residual entry 12 at serial number 3 of notification, there is an explanation. That explanation says that if the particular supply is covered by the previous entry, what is previous entry from 1 to 9, the new entries where the concessional rate is prescribed, then one has no option to pay to cover the activity under this residual entry. Residual entry, the rate of tax is 9%. That is total 18%. And please listen to very carefully. Residual entry says construction service other than the previous entries. And explanation says if something is covered, if a particular transaction is covered by the previous entries, where this affordable, non-affordable 1%, 5% rate is prescribed, if it is covered by that entry, then one cannot take the benefit of the residual entry. This explanation, idea is basically appears to be that the under this 1% and 5% without ITC is sought to be made mandatory by the legislature. That appears to be the idea. Is it really permissible, or does this have a sanctity in law? In my humble opinion, the answer is no. This explanation cannot be used to actually restrict the benefit of the substantial provision. Notification is, after all, a subordinate legislation. When construction service is considered as a works contract, that works contract has got a constitutional recognition. Then a notification which is a subordinate legislation, that notification cannot control which of the two benefit I should avail of. When there are two benefits available, that notification cannot curtail my benefit. The law is well settled. When a person is covered by two entries, two exemptions, there is simultaneously available, then it is for him to choose which benefit to avail. Please kindly see the Indian Petrochemical case, Supreme Court, and the Share Medical case. So, and there are a host of other judgments as well. So this explanation, the very the validity of this explanation, in my humble opinion, is very much subject to challenge. It cannot seek to curtail the right of the builder developer to opt for the full rate and then pay the tax at the full rate and avail the full credit. Next. 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 Coming to now, levy of GST on immovable property. Here, one may there are 2-3 aspects which we will need to, I would like to cover on this. The per se, the exclusion, which are the immovable property which would come into the picture. Then obviously the development rights, whether they can come within the broad scope of immovable property or not, and other attendant issues. Let me first get into the sale of land and sale of building. These two are covered within the scope of Schedule 3. Unless it is under construction, the tax liability is there. Otherwise, sale of land and sale of building have been held to be neither supply of goods nor supply of service in the Schedule 3. The question that arises is, was this really necessary at all? Before I come to this 1/3 value, was it necessary at all in mobile property? Whether there was any necessity to exclude the sale of land and sale of building per se from the purview, which are nothing but the immobile property. Sir, probably this apprehension or this provision has been made because of the vast definition of service. Service is defined as service, it means anything other than goods. There was an apprehension all around that since goods do not include immobile property, but service includes anything other than goods, therefore the transactions in land and building would also come within the purview of services. In my opinion, this apprehension was totally unfounded. And but anyway, because and there were a lot of views which were expressed, and taking note of these probably the sale of land and sale of building have been put under the Schedule 3. We may have to go back to the legislative scheme here of the constitutional scheme of the taxation. As yesterday I was mentioning, Article 246, read with Schedule 7, clearly demarcates the powers, legislative powers and taxation powers between the union and the state. Whereas the matters enumerated in Union List 1 are falling within the full only scope of only union. Matters enumerated in List 2 are falling within the powers of the state legislature only. This demarcation is well established, and encroachment by either side in another territory is not permissible. And the entire constitutional law is full of judgments on this occasional encroachment. There are quite a few, I mean, there are judgments and judgments on this. There are 2 entries here in List 2. One is entry 18, which speaks about the matters relating to land and rights in or over the land. And there's agricultural land and everything is there. And entry 49, which speaks about the taxes on lands and building. These 2 entry 18 and 49 are part of List 2. It means only state has got the powers. Entry 18 is a legislative entry. Entry 49 is a taxation entry. Now, if the taxes on lands and buildings is coming within the sole purview of the state legislature, where was the question of actually excluding it from the scope of the levy of GST by putting it under Schedule 3? That is one poser. The other aspect is Article 246A, as I yesterday mentioned. Article 246A is the authoritative source, it's a mother source from where the power to levy GST has arisen and the law has been made. Now it speaks about the union, that is the union legislature and the state legislature can impose GST and on the supply of goods or services or both. Now the GST can only be on the supply of goods or services or both. It cannot be on immobile property at all. Article 246 no doubt starts with the non-obstante clause. But in non-obstante clause, what it says, that notwithstanding anything contained in Article 246, it starts with that. At a prima facie, at a glance, one may feel that the Article 246A being overriding in nature over 246 Therefore, probably there could be a possibility of the GST being levied even on the immobile property. In my humble opinion, this is not so. Article 246A will be overriding or will prevail upon Article 246. The basic constitutional scheme of taxation powers and legislative powers is under Article 246. And that Article 246 will be overridden by Article 246A relating to GST only to the extent the matters are otherwise can be covered within the scope of GST. Immobile property cannot be covered within the scope of GST because Article 246A, which allows the levy of GST, is only on the supply of goods or services or both. So the very immobile property is outside the purview of Article 246A. That being the case, the power of the state legislature to levy the GST, to levy the tax or to provide for the taxation on land and building remains unaffected even after GST has come into force. That power lies within the state legislature only. It cannot be with, and therefore Stamp Duty and Registration Act are the powers which are the demonstration of these powers of the state legislature. The union legislature cannot levy GST on the immobile property and simultaneously state legislature also by levy the stamp duty on the land and building. The powers are only with state GST. These powers are absolutely unaffected by Article 246A, in terms of which ultimately the GST has been introduced and levied in this country, because it speaks about the supply of goods. Another aspect is that something can be excluded only if it is otherwise included or includable. If something cannot be included within the scope of the definition, it cannot be said to be excluded. There is no need to exclude them. Money or shares or securities can be goods in their own rights. And therefore, service definition under GST specifically excludes money, transactions in money and securities. Why? Because otherwise, service means anything other than goods. Though the securities and transaction are money are excluded from the scope of goods, they may fall under services, because services means anything other than goods. And therefore, there was a legislative wisdom to exclude transaction in money and securities right from both, from goods definition also and from the service definition. This cannot be said to be relevant, or this cannot be said for the immobile property. And therefore, in my humble opinion, the sale of land and sale of building, the very mention in Schedule 3, maybe it may be by abundant precaution, or maybe by soothing the ruffled feathers because people were apprehensive, but it has created, the very mention has created a lot of issues, because otherwise it was not required at all. Even without it inclusion in Schedule 3, in my personal opinion, GST could not have been levied on the sale of land and sale of building per se. I'm not talking about under construction. Please, yes. Now, you see the implications of this. One, once it is mentioned in the Schedule 3, the question arises, can it be treated as a non-taxable supply? And will it require the reversal of credit? Please refer to exempt supply definition. Exempt supply definitions under CGST Act includes non-taxable supply. Non-taxable supply has to be, there are two. One is, it includes only exempt supply. It includes a supply on which no GST is leviable under CGST Act or IGST Act. And three, non-taxable supply. Non-taxable supply is defined to mean a supply on which no tax is payable at all. A supply of goods or services or both on which no tax is leviable at all. Now the question here is, if the sale of land and sale of building has been categorized and characterized as a no supply of goods, no supply of services under Schedule 3, then can it be treated as a non-taxable supply? Because it has been stripped of the character of supply itself. If it is not a supply at all, then it cannot be a non-taxable supply, in my humble view. Now, therefore, it cannot come within the scope of exempt supply. And that is why under section, as I see that, under section 17.3, for the proportionate credit purpose, it has been specifically provided by way of some sort of a deeming provision that for the purpose of determination of value of exempt supply, the value of sale of land, sale of building, and transactions in security shall be considered. That should be taken in account. If it was already covered by the exempt supply definition, if this transaction of sale of land and sale of building were already covered by exempt supply definition because they were non-taxable supply, then there was no need to make this deeming provision under section 17(3). And I think there is a lot of disconnect, and there is a lot of internal contradictions in this end of non-taxable supply definition, the exempt supply and taxable supply proportionate credit provision, visa schedule. This is something which the policymakers may or the law framers may have to take into account. If the intention is to cover within the scope of the denial of ITC proportionately or otherwise, even in respect of the supply which is covered by Schedule 3 or otherwise non-taxable supply, then the law may have to be fine-tuned for that purpose. Today, the issue remains. The other part is that the para 5B, the immobile property, as I said, that the only way the transaction in under construction building is sought to be brought within the scope of levy is by carving out a artificial cutoff event called the issue of completion certificate, and now under GST first occupation, whichever is earlier, whichever is later. Now the question here is but for this, even in under construction flat also, when it is being sold, it is a transaction in immobile property. But if it is sold before completion certificate, the liability arises. Prior to retrospective amendment and after that also, the para 5B of Schedule 2. Schedule 2, as yesterday I mentioned, was never a deeming provision. It never gave any power in a deemed manner, unlike Schedule 1. To the legislature to levy the tax, though it has been interpreted, understood, and read in a different manner by everyone practically in the country, including advance authority ruling. All along, people have been reading Schedule 2 as a deeming provision. Personally, I have always felt that Schedule 2 was never intended to be deeming provision. And this is very important because if it is not a deeming provision, then the power to levy the tax will have to be traced back to Schedule Section 7 supply, read with Section 9 charging provision, and other attendant definition like business, as well as the consideration. The two, apart from now, the twin condition, transaction or activity that can be brought within the scope of the levy of GST are otherwise consideration and business. There should be a consideration, and it should be in the course or furtherance of the business, the particular transaction. If either of these conditions is not met, GST cannot be attracted on the supply by transaction treating it as a supply. Now, in two cases, these conditions have been dispensed with by the legislature. In one case, the condition of business has been dispensed with in case of import of service. And in case of Schedule 1 activities, the consideration condition has been dispensed with. That is a legislative discretion, legislative prerogative. No one can find fault with it. But unless, apart from this, for any transaction or activity to come within the scope of the supply, it has to be for a consideration, and it has to be for the business, and it should be a transaction in goods, supply of goods or services or both. Since per se, a transaction in immobile property is outside the levy, the Schedule 2 cannot be taken recourse to levy the tax on even under the under construction sale of the property. This is after the amendment, retrospective amendment. What has been done? Okay, if the transaction or activity is a supply within the scope of clause A of section 7(1), then its categorization as supply of service or supply of goods should be as per Schedule 2. This has been now made very clear. The intention has been made clear by retrospective amendment. Transaction has to be supply. Now, a sale of under construction flat, when will it become taxable? is it because of the new entry 1A in section 7, or whether it is because of 5B of schedule 2. 5B of schedule 2 cannot come into play unless the transaction is supply. And I cannot treat the transaction as a supply by saying that it is covered by 5B. In my humble opinion, this is slightly complicated, but in my humble opinion, even today, whether 5B is really a non-starter, there can be some serious issues in this. It would have been a different matter if this very provision would have put in a deeming manner, just like section 66E declared service. Please note the difference here. In the erstwhile service tax regime, the levy of service tax on the under construction unit sold by the builder before the completion certificate was validated by declaring it as declared service. It was a deeming fiction, which is the legislative power under section 66E. No such deeming provision today exists under CGST Act, nor under Schedule 2. Do we really need the deeming provision to make the levy valid on the under construction sale of the property? In my humble opinion, yes. Highly litigation prone view, but this is my view. Otherwise, without deeming provision, if service levied, then there was to make it a declared service. So this is something again, which one may have to give a serious thought to. The other aspect is about, as I said, by inclusion of sale of land and sale of building, unnecessarily the issues of that reversal of the credit has arisen. Take a case of quite a few participants would be chartered accountants in this webinar today. Let us say a chartered accountant has inherited a ancestral property. He is in a metropolitan city practicing, paying the GST also, availing the ITC also. This can be true for any businessman also. And he has actually some ancestral property, say, which land in a native he is selling during 2021. Now, because sale of land is now for the exempt supply, the taxpayer chartered accountant would be now considered to have indulged into two activity: extra supply in the form of sale of land and his taxable activity as a professional chartered accountant. And he is availing the ITC. He will be now required to allocate the proportionate credit only because he has undertaken the sale of land, which has nothing to do with his taxable professional activity. No part of his ITC has anything to do with indirectly, as a matter of fact, unless somebody says that he has taken the ITC on the telephone services and he is using the telephone for the purpose of the clicking the deal of the sale of land. This type of absurd situation can arise because sale of land taking place even innocently by a person, taxable person, who otherwise pays the tax and availing the ITC will be hit by section 17(3). The same thing can happen if somebody is selling the property, some extra bungalow or some extra flat or some extra residence or anything. It is a sale of building or part thereof, obviously. And if somebody sells the property, he would be probably in the form of this flat or office or anything, he would be hit by section 17(3) because it is provided that for the purpose of proportionate reversal for exempt supply, value of sale of land and sale of building will have to be taken into account. And this can have, in the coming years, probably there could be a lot of issues on this. Next. 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 Coming to now development rights, this entire issue, I will take it up in my joint development related studies because it is coming forward in there also. Next. Yes, you can move forward. Let me complete the majority of these other issues. Next. Next. Yeah, these are all part of the joint development agreements. Next. Yes, go ahead, this. Yeah. Yeah, this is just, hold on for a minute. The previous slide. Yes, this is just to acknowledge as a protocol, but there was a long duration knowledge sharing webinar on Indian real estate sector recently organized by Hyderabad Study Group and Delhi chapter of CTC jointly with Federation of Tax and Accounting Professionals, New Delhi. And as a part of that, it was a long duration. There were 12 sessions altogether where the various aspects of real estate sector were discussed from the GST perspective and income tax perspective. And there was a panel discussion in which all the issues, case studies relating to JDA, where GST portion was addressed by me, and income tax perspective was addressed by respected Sri Devdas. And,
Sir, sorry to interrupt you. Actually, your face is not visible. So kindly.
No, that's what I am saying. That there is some problem. I don't know why.
Actually, just slide. आपकी चेहरा हल्की सी पीछे लीजिए सर. Actually, आपका चेहरा दिखने नहीं दे रहा है.
अच्छा, okay. Is it okay now?
Let me see. Please video. Yes, sir.
I don't know why the video is. I am unable to. आप वहाँ से कुछ कर सकते हो, please.
एक मिनट से मैं देखता हूँ सर.
Yesterday I was able to see myself in the box, which was very, convenient for me. Today I am unable to see anything.
Sir, we are checking right now.
Huh?
So we are checking once. Actually. सर आप अपने चेहरे पीछे लीजिए ताकि आपको पूरा चेहरा दिख पाए यूजर्स को पूरा.
Yeah, that's right.
Yeah, this is perfect now. Right now.
Actually, I don't know why I am.
Actually, we are able to see you. No, all users are able to see you.
Okay, I am only unable to see myself. Otherwise,
yeah, actually, all
me.
is.
Anyway, we will continue.
Sure.
Okay. Sure. So this was the part of that panel discussion, and which I would take up one after one. The first case study. Next, please. Here the facts are, just go to the second slide. Next slide. Yes. Sorry, first, previous slide, please. Yeah, previous. I will leave aside the IT's part. That is not my cup of tea, please. So here the facts which have been, first slide only. Previous one, yeah. Mr. Jamindar landowner has entered into a joint development agreement on 14 January 2014. And friends, please mark the date. This is pre-GST. There is a joint development agreement with Vikas developers for development of residential complex on his land. The JDA was duly stamped and registered in January 2014, transferring the development rights irrevocably to the developer. It was an area sharing arrangement wherein 40% of FSI was retained by Jamindar, landowner, and balance development potential was transferred to the developer. Developer was obliged to allot 40% of the total constructed area to Jamindar. The project is completed on 30th April 2019. That is post-GST and post new tax structure. Both the parties were selling the units during the construction period. Kindly enlighten on GST application of Jamindar and developer. Next. Now, if you see, the issues which arises are that leviability of service tax and GST on transfer of development rights. This is a typical joint development agreement which are normally entered into between the landowner and the developer. Landowner is sitting on the land developer is actually starving of the land. So both come together. One has the land, another has the expertise and resources to construct, develop the land or exploit the land. And this is how the mutually beneficial arrangement are worked out. In a country like India, this is the standard way people, and it can be an area sharing, it can be a revenue sharing also. Now, here, for the purpose of case study, I had made some assumption that JDA was acted upon in pre-GST. It means the commencement, construction was commenced prior to 30th June. Sale of constructed units by both the parties. Landowner was also selling and the developer was also selling pre-GST and post-GST. Project was completed in April 2019, but completion certificate is still awaited. And possession of the constructed unit was received by the Jamindar partly before 30th June, before GST, and partly after GST, but not after 1/4/2019. We will see that. So these are certain assumptions which I have called out on the basis of this case study. Now let us see the leviability or the GST implications in both the cases from the landowner perspective and from the the developer perspective. And please remember, this covers both pre-GST period and post-GST period also. Next. Now, let us first take up the service tax. The issues which, as I have already said, whether the agreement in question and the arrangement postulated thereunder constitute joint development agreement or a principal to principal agreement. Friends, first of all, always we have to keep it in mind the distinction between the joint development agreement and the joint venture. These are typical joint development agreement. These are not joint venture. If it is a joint venture, the whole context of the taxability will change. Joint venture is a very, very different and in a way a very legal phenomena, a very independent, distinct legal phenomena. And what the joint venture is, what are the attributes of joint venture, when a particular venture can be, when a particular arrangement can be said to be joint venture. One of the celebrity judgments on this is by the Supreme Court in Fakirchand Gulati's case. This judgment has been subject matter of intense discussion over the period. It has been followed, it has been distinguished, but this is something a judgment will have to be kept in mind, where Supreme Court has discussed in detail about the various characteristics and attributes of the joint venture, and in a Fakirchand Gulati's case. But this is the typical joint development agreement. Now, coming to the leviability of service tax. The relevant period is agreement has been entered into in January 2014. That is post negative list based levy of service. We have seen that yesterday, that service definition 65B44 excluded transfer of title in goods or immobile property by way of sale, gift, or in any other manner. And such transfer, otherwise, if it is declared as a deemed sale, coming within the scope of deemed sale as per clause 29A. So the first question from the developer's perspective, Jamindar or landowner perspective that arises is whether development rights which he is transferring irrevocably constitute, attract the levy of service tax, or whether it constitute an immobile property. Because if it is a transfer of title in immobile property, then it is outside the purview of the levy of service tax. And I'll come to GST also, but first the service tax, because without understanding that we might fall into error if we go straight to the GST. Next. And I'm sure there are disputes which are mushrooming on this issue, the past dispute, which are still actually at various stages. Next. If you see the definition of immobile property, the word immobile property has been used in the definition of service tax by way in the exclusion clause. It is not used in GST. Okay. Now, if development right or floor space index, can it be considered as an immobile property or not? That is the first and foremost question. And here, if you see the immobile property definition, immobile property was never defined in Finance Act 1994. So we have to take the recourse to the Land Acquisition Act or the General Clauses Act. All along, immobile property has been defined to include land and benefit arising out of land, things attached to the earth, or permanently fastened to anything attached to the earth. Now, so immobile property includes land and benefit arising out of land. if you see the definition of land, this definition under various enactment clearly specifies, refer to Land Acquisition Act 1894, Section 3, Clause A, Bombay Land Revenue Code 1879, Section 3, Subsection 4, General Clauses Act 1897, Section 3, Subsection 27. In all these cases, the land definition includes benefit arising out of land also. Since benefit arising out of land is covered within the definition of land, the phrase benefit arising out of land has also been subject matter of intense debate and consideration in many judgments by the Supreme Court and by the other courts and tribunal also. What is this benefit arising out of land? In the case of Girnar Traders versus State of Maharashtra, 2011 3 Supreme Court cases 1, the court held land development right is a right to carry out development or to develop the land or building or both. It is thus benefit arising out of land and included within the word land. In the case of similar view was taken in State of Orissa versus the Titagar Paper Mills Limited also. Again, there is another judgment of Bibi Saida versus the State of Bihar. State of Orissa versus Titagar Paper is a case, All India Reporter 1985, Supreme Court 1293. There also the similar view was taken. One can also see the judgment in S.N. Chandrasekhar versus State of Karnataka, 2006 3 Supreme Court cases 208, as well as Dena Bank versus BBB Parekh and Company, 2005 SCC 694. And the view is land development right is a right to carry out development or to develop the land or building or both. It is a benefit arising out of land and included within the word land also. In Pradeep Oil Corporation also, 2011 5 SCC 270, it was observed that land includes benefit arising out of land. In fact, in quite a few cases, it has been in the context of the profit a pendre, it has been said that okay, once I have the authority to enter a estate and if I'm catching the fish, then catching the fish is also it is a profit a pendre and arising out of it is a benefit arising out of land. Felling, cutting and removing bamboos from the forest for the manufacture of paper is a benefit to arise out of land, and hence it would be an interest in immobile property. This was the view in the Titagar Paper Mills. Right to enter upon the land and cut the tree is a benefit arising out of land. Santabai versus State of Bombay, All India Reporter 1958, Supreme Court 532. Lake is an immobile property. A water lake is an immobile property. And therefore the petitioner's right to enter in that estate, which he does not own. He is not owning the lake, but he has a right to enter the estate and take away the fish from the lake is a profit a pendre, and in India it is regarded as a benefit to arise out of land, and hence it is an immobile property. Anand Behara versus State of Orissa 1955 to SCR 919. There are a host of other judgments. I'm not going too much into detail. These are just judgments. That being the case, the development rights or FSI as we call it is nothing but a benefit arising out of land, or it is a benefit which is which owes its existence to the existence of the land. If there is no land, development rights could not come into existence at all. If a particular benefit owes its existence or birth to the existence of land, like development rights or floor space index, it is a benefit arising out of land. So the same thing goes with the TDR also. Transferable development rights, which is a prevalent feature in where the landowner's land is either taken away or is encroached upon and it is to be freed under the SRS scheme or MADA scheme. The competent authority, state government authority, issues the TDR in favor of the landowner. And these transferable development rights in the form of a certificate is freely tradable in the market. And this TDR then can be exploited for the purpose of construction activity and sale of the constructed units by the builder, developer or the holder of the TDR subject to various regulations. This TDR is also owning his existence or birth only to the land. And it has been very recently by Commissioner Appeal has held that the TDR comes within the scope of the land and then immobile property, so no service tax is leviable thereon. So be it development rights or be it the TDR or FSI, whatever you call it, this comes within the scope of land. It is a benefit arising out of land. Land is covered by the definition of immobile property, and therefore the question arises whether they can be subjected to levy at all. And the words used under service tax is transfer of title. Title is a broader expression of law which need not be always understood as akin to ownership. Title in a property may take various forms of the right in a property. It is now a very settled law that a ownership in the property is consisting of the bundle of rights. This bundle of rights can be for the right to possess, right to develop, right to occupy, right to tenancy, right to easement, right to lease out. These are all different rights which constitute a bundle of right in a property, in a land. And that right are all separable. That right all are basically can be independently vested in somebody subject to or can be sold or transferred also. One need not transfer the entire ownership of the right in the property at the time of transfer of development rights. This is a very well recognized legal position. Every single right can be independently separated and then can be actually transferred. Development right is one of such rights, right to develop. And therefore, even without transfer of ownership in land, I can transfer the DR which constitutes the transfer of title in immobile property, because title need not be equated with the ownership. One can say that basically when I'm irrevocably transferring the development rights, I am actually transferring the constructive ownership in the property too, because I am allowing, landowner is allowing the builder to sell the unit which is constructing on that by exploiting that development rights. In the given case study, 40% development rights which are given on the 40% of the land, whatever is constructed by the developer, he will be also having the authority to sell those units. And therefore, there is a sort of a constructive, because there will be a tripartite agreement. And the landowner will, then in the tripartite agreement, landowner will be agreeing to transfer the undivided share in the land also to the ultimate buyer. And his consideration is in the form of cash or area sharing that will come to later. Therefore, development rights may also be considered as a transfer, irrevocable permanent transfer of development rights can be also said to be akin to the transfer of the constructive ownership of that area of the land. But even without that, there is definitely a transfer of title, because title is a broader expression. Next. So the next. Next. Yeah. Once that is the previous one, please. So once there is a transfer of one of the right which is permissible, and here it is a development right, regulation 34 of development control regulation even says the development right is a development potential of land that may be separated from the land itself in certain circumstances. This is the DCR rule 34, regulation 34. And that being the case, and as I have already dealt with the entry 49 and entry 18, the conclusion is this: transfer of development rights by jamindar or landowner to developer against the allotment of the constructed area in terms of the agreement is a transaction in immobile property or involving a transfer of title in immobile property, and therefore it stands excluded from the scope of service as defined under section 65B44, cannot be subjected to service tax. This is the first conclusion I am reaching. Coming back to the GST. GST does not use the same terminology. In fact, CGST Act and the schedule thereto do not even use the word immobile property anywhere. But as I said, one, GST is only on the supply of goods or services or both. So whether by implication or whether by any direct approach, immobile property cannot be said to be covered within the scope of the levy at all in any way. Even if it is excluded, it cannot be said that but for the exclusion, it was includable or it was already included, and therefore legislature has excluded. In other words, if the sale of land was not excluded, would not have been excluded, can somebody say that sale of land would have been covered under service? In my humble opinion, the answer is in negative. Having said that, now land is already covered under Schedule 3. We have already seen that the development right is a benefit arising out of land, because but for the existence of the land, development rights would never come into existence. It owes its birth to the land. That being the case, similarly for transferable development rights, that being the case, once the development right is covered within the scope of the land, land is covered within the scope of the definition of immobile property. So whether I stop at land or whether I take it forward to immobile property, development rights remain outside the purview of the levy under GST. That is my second conclusion in the context of GST. There is another aspect. GST here in the particular case study, the transfer of development rights under joint development agreement took place prior to GST. Assuming for a moment that this transfer of development right constituted a taxable event liable to service tax. What is the taxable event? The taxable event is the execution of the JDA at the material time. It is the date of execution of the JDA when the irrevocable transfer has taken place between the Jamindar landowner and the developer. Once the taxable event has taken place during the pre-GST period, the grant of possession or allotment of the constructed area by the developer to the landowner Jamindar during post-GST cannot create or give birth to an independent taxable event attracting levy of GST. In other words, post 1st July 2017, whatever units, constructed units are being allotted by the developer to the landowner in terms of the JDA executed prior to GST, those in respect of that proportionate development rights, I'm now only on from the landowner perspective, please. I am not saying anything from the developer perspective. Landowner has given certain development rights on 40% of the area, against which he is expecting some constructed area from the developer. That constructed area partly is given prior to GST, partly is given after GST. My first proposition is development rights are not liable to service tax at all. Now, the constructed area which is allotted by him post GST, that constructed area cannot make the land owner liable to for the proportionate payment of the GST. There is no provision. Taxable event has taken place already. A new taxable event cannot be said to have can be taking place on the date of possession post GST also. So no liability whatsoever for the development rights, supply of development rights by the developer landowner in this case. Next. Now, there have been two circulars on this. The 2012 circular, which was later on followed by 2018 circular, and notification 4 by 2018 post GST, and para 6.2.1 of the education guide as well. In all these, if you see very carefully, without going into the, I'm not going into the details, but if you see in this, all these circular, the sum and substance of the board thinking has been really they have concluded that development rights, transfer of development right is a consideration in kind, and there is a difficulty and the value thereof cannot be ascertained. That has been very clearly stated in these circulars. It is not ascertainable. This part of the observation by the board in this circular has remained, in my opinion, undisputed or unaffected, or it has not been altered in any manner whatsoever. There have been attempts to levy the tax on this, but the unascertainability of the considered value for the development right has remained a core matter always. And then what has been done on 25th January 2018, notification 4 by 2018, this is post GST, which has been actually issued, whereby the time to pay the GST on the development rights obtained by the developer were shifted to the possession or allotment of the unit. This is basically notification issued under section 148. And section 148, this notification is merely basically shifting the time of supply. But it has been worded in such a manner that it seeks to create a levy in a form of charging notification. In my humble opinion, 4/2018, and followed by the similar notification under Post 1/4/2019, we'll come to that. This notification is absolutely invalid because it assumes the taxability of development rights, and in a hidden manner, it seeks to create, in an oblique manner, it seeks to create the levy on the transfer of development rights in the guise of shifting the time of supply to the possession or allotment of the unit under a conveyance deed. Coming to the constructed units allotted by the developer to the jamindar, there are, whether it is service tax or whether it is GST, the developer is obtaining the development rights in the 40% of the land. As against that, he has agreed to give certain area, constructed area, to the landowner. Is it not? It can be said that this is merely a barter arrangement. This is or it can be an exchange. Barter and exchange are two independent things. The one proposition can be that it is a barter in immobile barter arrangement. Another proposition can be that it constitutes exchange of immobile property. Because both the sides, there is no consensus ad idem on the provision of service by and between the contracting parties. The landowner is basically not engaging the developer for the provision of service, and the builder developer is not actually obtaining any service in the form of buying the development rights from the landowner. Development rights is an immobile property. Under the constructed area given by or agreed to be given by developer to the landowner is also immobile property. Both parties are, contracting parties are entering into some arrangement, exchange of immobile property. From this perspective, whether the transaction can go out of service tax and GST, a highly debatable proposition, I must say. But yes, this view is plausible. This view can be taken. Next. The GST, again, as I said, if it is the transaction of exchange, or one may even go to the extent of saying barter in the immobile property, and there is no consensus ad idem between the contracting parties for any provision of supply of service, then this is going out of GST also. The next question that arises, whether the transfer or grant of DR by Jamindar to the developer constitutes consideration in the hands of the developer. Here, Bombay High Court in Sumer Corporation has said that transfer or grant of development rights may constitute consideration in the hands of the developer under service tax and GST because of the Bombay High Court judgment. That being the judgment, assuming that the constructed area, therefore, if we leave aside the barter or exchange part of it, then from the developer perspective, what is the consideration he is getting? That consideration is in the kind of, in the form of development rights. It is the consideration in kind. What is he providing? As against that, he is giving constructed area to the landowner. He has received the consideration in the form of development rights. As against that, he is providing the service in the form of allotment of the constructed area. And therefore, assuming up till now, okay, there is a consideration, there is a supply of service. Let us assume in the form of we are talking about under construction, no completion certificate. Then the question arises, how to determine the value? Because if this consideration is accepted, the development right is accepted as a consideration, it is a consideration in kind. Then how to arrive at the value? Because without that value, there could be an issue. Now that valuation provision, whether as far as the GST is concerned, if you very carefully see Rule 27 to Rule 33, this is a whole consideration is in kind. There is no cash involved here. Please understand that. Developer is not paying any amount in cash to the landowner for obtaining or for the grant of development, partial development rights. Being 100% consideration in kind, if you very carefully see Rule 27, in my opinion, Rule 27 does not even cover this type of situation, okay, where the entire consideration is in kind. It covers a situation only when there is a consideration partly in kind and partly in cash. The two illustrations given below, Rule 27 also will make it very clear that whatever may be the intention of the legislature while framing Rule 27, it does not cover a situation where the entire consideration is in kind. It was a different matter under service tax. Service tax valuation rules were much more better worded, where that it covers section 67 read with valuation rule could have covered this type of situation where the entire consideration is in kind. If you see the title or heading of Rule 27, it actually the intention is different, but that is not percolated down or reflected in the actual language in the illustration under the Rule 27. And heading does not determine the scope of the rule. That is the scope of provision is not determined by the heading. So the first thing, one, assuming development right is taxable, assuming development right constitute consideration, assuming that against that consideration developer is providing constructed area to the landowner, the question of valuation will be a issue. Even if landowner were to made liable to pay the tax, on what value will he pay the tax? This will apply even in any new arrangement after 1/4/2019 or even after June 2017 onward, 1/7/2017. The valuation provision failed because once Rule 27 does not come into play, the remaining rules cannot come into play at all. Even the residual Rule 33 also only speaks about that if it is not ascertainable as per the foregoing rule, then it should be ascertained by applying any of the foregoing rule in a reasonable method. But if this cannot be done indirectly, if any of the foregoing rule cannot come into play, residual rule cannot bring it into the play. If the earlier rules are incapable of application, then the residual rule cannot apply it. I mean, that is obviously not permissible. It cannot be permissible. Therefore, once the valuation mechanism fail, one of the four characteristics, character of tax, that is the event, taxable event, the rate of tax, the person liable to pay the tax, and the value of the tax. All these four essential prerequisites for the valid levy of tax as held by the Supreme Court in Mathuram Agarwal, B.C. Srinivasa Shetty, and Govind Saran Gangasaran, one of the test of valuation fails and therefore the levy fails. There is no valuation mechanism for the determination of the development rights which are given if the 100% consideration is in kind. There is no mechanism today under valuation rules. Next. Next, please. So then the question also arises about the relevant date on a sideline. What is the relevant date? Because section 67A of the erstwhile service tax rules talks about date of determination of rate of tax, value of taxable service, and rate of exchange on the relevant date. And relevant date after POT rules have to be determined as a date of issue of invoice or date of completion of service or date of receipt of the payment, whichever is earlier. Now, if the date of execution of JDA is relevant date, then the question of bringing GST into picture does not arise at all, because the agreement has been entered into much prior to. My transfer of development right, which is an event that has already taken, even if it is assumed to be a service, the service is already completed on the execution of the agreement. So from that perspective also in the given case study, the GST cannot be made applicable. Next. Next. I have already covered this. The GST, if you see Rule 27 to 31, sorry, not 33. Yes. When the valuation mechanism fails. Next. This part also earlier I have covered, that entire thing about Yes, here I may have to say that this entire issue about the levy of the state power or the union power to levy the tax on building, land or building, particularly in the context of the mining rights, is at present pending before the 9 judges bench of Supreme Court in Mineral Area Development Authority versus Steel Authority of India. And it has been recently cited also in 2018-13 GSTL3 Supreme Court. It is understood that this matter, it is a matter of far-reaching importance. It can have a extremely major impact on the entire constitutional arrangement and the union and state power to levy the tax on the land or transaction or activity or service which are having the nexus with the land. There are some important issues involved in this entire matter, and probably it might even be going to the 15 judges bench. But as of now, it is a matter pending before the 9 judges bench in the. So we'll have to just keep the watch on this interesting development as well. Next. In this case study, we take off from the earlier case study. Here, the only difference is that there is a revenue sharing and not the area sharing. In other words, in the same set of arrangement whereby the landowner grants the development rights on the part of the land to the developer, instead of constructed area in return, he is actually sharing the revenue with the arising from the project. And this sharing of the revenue is also prior to GST, after GST, up to 31st March 2019, and post 1st April 2019 also. So 3 periods are involved. Prior to GST, then that is during negative list, then between 1/7/2017 and 31st March 19, and after 1st April 19 also. Next. Now, as far as the major conclusions are concerned, it is the same. I'm reaching the same conclusion in all these cases. Whether it is a revenue sharing, it means development rights cannot be subjected to the transfer of development rights, cannot be subjected to the levy of tax at all. That is the conclusion. There is, as I said, just to reiterate, that under this type of joint development agreement, when the landowner irrevocably and permanently transfers the land development rights, whether for the case revenue or area sharing or both, he is basically simultaneously also giving the right through a power of attorney to the developer to sell the units constructed on their land. Thus, it is the possession of land. It is not simply the transfer of development rights. It is also the irrevocable and permanent transfer of the rights to develop a land and then also sell the units also. And once that is so, once the developer gets the right to sell the property constructed by him on the land for which he has acquired the development rights, for which there is a tripartite agreement entered into between the developer, landowner, and the buyer of the flat, then this is definitely is a transaction in the immobile property. Landowner indirectly gets the consideration also in the form of is receiving the consideration against the sale of interest, the revenue here also which he is getting. That being the case, now coming to after 1/4/2019, where he is getting the revenue in this case study, case revenue with the landowner is getting. Because if you mark in this case study, it is proposed that both the landowner, landowner and the developer are selling their respective share of the units during the construction period. So CC is not received as on date. Developer has obtained the development right which he is exploiting. Simultaneously, he is selling the units and the revenue is being shared between the landowner and the developer. That is a landowner consideration in cash. Part of the consideration he is receiving after 1st of April. And he is also selling. The landowner himself is selling his area of the share which he is getting from the constructed area from the let us take this that way. Okay, instead of revenue sharing from the landowner, there could be a possibility that the landowner himself is selling during the under construction period. You are aware that notification 3/2019 under the condition, there is a provision whereby a new concept has been evolved, that is of the promoter landowner. And this landowner promoter concept makes the landowner promoter liable to pay the tax on the units which he is selling under construction, which he has received from the developer to whom he has given the development rights. There are two conditions attached to it. One, landowner promoter cannot sell the unit below the price at which he has actually been given by the developer. And two, he is entitled for the ITC which of the tax which is charged by the developer to him, to the landowner, while giving the constructed area. And he will be entitled to pay the tax at the 1% or 5% depending upon the category of the unit, affordable or non-affordable. Now, these are the two distinct arrangements. Question in how the landowner promoter is defined. A landowner promoter is a promoter who transfers the land or development right or FSI to a developer promoter to construct for construction of apartment and receives constructed apartment against such transferred right and sells such apartment to his buyer independently. Is this previous one, please? I'm on case study only. Now, the first question that arises is, it is one thing to define the landowner promoter. Can the landowner promoter be said to be providing any construction service to the ultimate buyer to whom he is selling the unit which he is receiving from the developer under the JDA? That is the moot question. Can he be said to be providing these services at all? Can he be? Is the buyer is engaging the landowner promoter for construction of the unit or the construction of the building in which he is buying the unit, unlike the developer? Whether the subordinate legislation can create a charge or levy in this manner, in an artificial manner, I have serious reservations about the very validity of the levy on the developer promoter, landowner promoter. In this manner, in my opinion, the serious challenges lie to this particular provision, whereby the landowner promoter has been made liable to pay the tax on the units sold by him under construction, which he is receiving from the developer against the transfer of the development rights. I have serious reservation. He is being put at par with the developer builder, for which, according to me, no authority, actually, there is no, the power do not exist. A subordinate legislation cannot create the levy in this manner. Even para 5B also says, construction of a supply of service, construction of a complex, including a complex or building intended for sale to buyer, wholly or partly. The landowner promoter is not undertaking any construction whatsoever. It is being undertaken by developer promoter. In my humble opinion, there has been a query. Same logic should apply even in case of the investor. If an investor has booked a flat or unit in an under construction property, which is selling during the course of under construction stage only, he is not coming within the purview of the levy, because he is not even the landowner promoter. He is an investor, a normal buyer. As a buyer, he is buying a under construction property. As a buyer, he is, as an investor, he is selling that under construction property to somebody else. Even just merely because, yes, builder developer may charge to him, but a investor reselling the property under construction cannot be subjected to GST, in my humble opinion. Such transaction ideally should take place through the sale of deed only. There is no even question of issuing any invoice at all, in my humble opinion, even if the investor is otherwise a taxable person engaged in some other taxable activity. But otherwise it is not. These are all the issues which will need to be tested before the court of law. But there is a lot of convenience, which have flown into in this entire scheme of the thing. There is a lot of compromise, lot of the line of least resistance, and the convenience which have gone into, the psychology of convenience has gone into framing this provision. But at many places, I'm afraid it has gone beyond the mandate of the fundamental provision, mandate of the Constitution, and therefore the challenges lie. Next. Now, Here in this case study, A is the landowner owning parcel of land since 1980. The original purchase cost of the land was 1 crore rupees and present market value of the land is 100 crore. He intends to develop the residential cum commercial complex in collaboration with a renowned developer. LLP was formed on 15 December 2018, having Mr. A and Mr. B as partners, having profit share of 70%, 30%. A has transferred development rights at market value to LLP. A is a landowner, as is capital contribution, and developer is expected to bring capital to fund the development and construction costs. The approvals for construction of the project is received after 11th May 2019. That is after the new tax structure came into place. What are the GST implications next under this LLP? To simply put, A is bringing the capital in the form of the land and B is bringing the capital in the form of cash. And both undertake under the aegis of the LLP, both undertake the development and then the units are sold in the market. Now, whether the capital contribution by way of development rights and capital contribution in cash by the respective parties, that is landowner and developer, whether can be subject to liable to GST, whether the LLP can be said to be. It is like whether admission of a partner for a capital contribution in a firm, will it constitute supply of service making the firm liable, or whether the holding of the shares or investment in shares by a holding company in another undertaking for which he is receiving the dividend, can it be said to be a supply of service in, or whether will it attract the GST liability or not? These are the issues which are at the maybe at the very nascent stage in our country, because the law is just taking its foothold in the country. But these issues have arisen, and in the coming years, many such issues would now definitely will be coming to the fore in India also, which more or less follows the international, the model of the GST or VAT. These issues have arisen before the European Court of Justice time and again in the context of the 6th directive of the European VAT. And here I will just refer to only 2 judgments. These are the only issue which I am culling out of this case study. And European Court of Justice, I'll just refer to, there are quite a few judgments, but I'll just refer to only 2 judgments in which these are all celebrity judgments, outstanding judgments of European Court of Justice. One is in the case of Polisar, the case number is C60 by 90, 1990, where the European Court of Justice has concluded that holding of shares in another undertaking would not constitute a taxable supply and therefore cannot be liable to the VAT at all. Under these circumstances, the company will also not be entitled for the VAT deduction, what we call as input tax credit. Under the VAT jurisdiction, European VAT, it is known as a VAT deduction. It will not be entitled for that also. Holding of shares for which the company is receiving dividend. There is an interesting observation in this case by the European Court of Justice, which has actually opened up the Pandora's box and which is a subject matter of debate even today. And that is, unless the holding of such shares ultimately results into the managerial control by directly or indirectly in the hands of the holding company. There are some further observations. I am right now not going into the detail. But otherwise, simpliciter holding of the shares for which dividend is received by the company would not constitute a supply. There is another case in the context of the partnership firm. It is a KPEG rendite funds. The case number is 442 by 2001. In this case, the European Court of Justice clearly held that admission of a new partner against contribution in case in a firm is not a supply of service by the firm to the new partner and therefore cannot be leviable to VAT. Whether it is a contribution in kind or whether it is a contribution in case, the ratio of this judgment will apply. It is a case of KPEG versus KPEG rendite funds, case number 442 by 2001. I've seen the ratio of this principle laid down by European Court of Justice would squarely apply, and mere contribution of the development right. It cannot be said that the landowner is transferring the development rights to the LLP on which the GST liability can arise, simply. And the case contribution, capital contribution by the developer obviously cannot be subjected to GST. Next case study, please. Here, go to the next slide. Yes, the factual metrics, just to gist, landowner and developer enter into JDA on 15 January 2020 to develop a commercial complex on area sharing basis. Proposal is to lease out 100% of units from their respective share. A non-RERA project and expected to be completed in financial year 2023-24. The issues are GST implications for the landowner and developer, and another is admissibility of ITC credit of GST outgo in execution and completion of the said project. First is leasing of the land. As you are aware, it is liable to 18% GST. The question here arises is that both have entered into a JDA to develop a commercial complex. It is a commercial complex on area sharing basis. And both are selling their respect. Suppose it is a 50-50. So landowner also is selling the leasing out the units out of his 50% share, and developer is also leasing out of his 50% share. Now, that being the case, the question arises here whether this leasing out is no doubt taxable activity, but whether the parties would be entitled for the, or the entity would be entitled for the ITC. Difference you must have actually by now goes that this issue is a direct bearing, is a directly arising from the section 17.5 C and D. Section 17.5 D of the CGST Act debars the availment of ITC on the goods or services used for the construction of an immobile property, even if the supply is on its own. In other words, to simply put, if a developer is developing a commercial complex in which the units are to be let out by him, because residential unit dwelling, if they are let out, there is no tax at all. But if the commercial units are constructed in a complex which are let out, then on that he is liable to pay GST. But because of section 17.5D embargo, he is not entitled for the ITC. This issue, before we come to Safari, let us go into the background of this issue, how it has arisen. Next, please. The genesis of this controversy can be traced back to 2008 under service tax. Under service tax, there was a circular suddenly issued by the board on 4th January 2008, whereby they said that during the course of construction of a commercial complex, an immobile property in the form of building comes into existence. So whatever construction material and services which were earlier defined as an input and input service, and the same now, whatever input and input services have gone into the construction of this complex in which the units are leased out, it is actually stopped at the immobile property. Once the immobile property in the form of commercial complex is constructed or comes into existence, the credit chain stops there. So subsequent leasing out of the unit on which service tax is being paid, it is of no relevance and no credit can be allowed. And please bear it in mind, at the material time, in input and input service definition, there was no such restriction. This matter went into before the tribunal in Sai Samhita storage case, and tribunal Bangalore held that there is no such restriction, and once the construction material and services are used for the construction of a commercial property in which the units are leased out on which service tax is being paid by the taxpayer, then it can be said that the construction material and services are used for the provision of the taxable service via construction of immobile property, and therefore no credit cannot be denied. This case has been approved in Andhra Pradesh High Court, and very recently in 2015, Supreme Court has no doubt admitted the appeal against this case, and it is pending as on date. In Mudra Port and SEZ, Ahmedabad Tribunal, however, disallowed the credit in this case on the ground that steel material used for the construction of jetty, which ultimately is used by Mudra Port for the port services on which the service tax is being paid, will not be entitled for the credit. This part of the judgment, which otherwise is in favor of the party, this part of the negative verdict against the party was challenged before the High Court, and the reference was answered by the High Court in favor of the appellant in Gujarat High Court is held in favor of the appellant. That can CENVAT credit on construction material or services cannot be denied, which have gone into the construction of the jetty, which jetty part of the port on which ultimately it is used for the port activities on which service tax is being paid. Both these judgments have been referred to in umpteen number of judgments thereafter. They have been followed also. Amidst this controversy, for some reason, the revenue or policy makers were adamant that they don't want to allow the credit on the construction material which are used for the construction of commercial complex where the units are leased out. For whatever may be the logic, unfortunately, but that has been a dogmatic stand on part of the revenue. We don't want to allow the credit, and therefore, amidst this judicial legal controversy, input and input service definition were amended from 1/4/2011, and it was followed by another amendment after negative list came into place, and thereby specific exclusion was carved out, whereby the credit on input and input service was denied if it is used for the construction of any immobile property, if it is used for the renting out or leasing out. I'm not going into the wording of the limited, but they have continued with their philosophy despite the judicial pronouncements and despite the old logic behind the weight philosophy. And surprisingly, at least till today, I might have missed, I don't know. I have not come across a single challenge to this amendment to Rule 2K defining input and Rule 2L defining input service after its amendment on April 11, whereby this benefit of CENVAT credit was taken away in these circumstances. Unlike the earlier, there has been no challenge. It is as if the sector accepted, if you are denying me the credit, I'm happy with that. Is it because of that there has been no challenge that probably the policy makers or the law framers were emboldened or the revenue was emboldened to continue with the same philosophy even under GST? That is the question which probably it needs some self-introspection. Next. Sorry, previous one. Yeah. So same philosophy, if you very carefully see, the amended Rule 2K and Rule 2L of the CENVAT credit rules 2004, if you compare them with the current section 17(5)(d), the intention is very clear that there is a, the credit is not being allowed on the construction material and services used for the construction of complex, which are used for the leasing out of the unit, though the tax is paid. Now, this was challenged in safari retreats by the High Court, and in safari retreats, please mind, the Honorable High Court has not declared it ultra virus. They have read down the provision that such denial is not justified, and they have declared that the benefit is admissible. It is a judgment sitting on a very precarious age, and it is right now pending before the Supreme Court. Meanwhile, based on the safari rate, very recently, Karnataka High Court, and there are some challenges pending even in the Madras High Court, so Karnataka High Court has allowed the party to utilize the credit also. This is a case of Bagmane developers. In Bagmane developers case, very recently, only about 2 weeks back only, what has happened is, similarly, the party took the credit of ITC on the construction material and services of 17-18 after safari retreat. Credit was taken in 2019 after the presumably the period of the limitation over as per section 16(4). They took the credit of 17-19, though it was only a very minor portion of the credit. Total amount involved is 62 crore. Very minor portion was pertaining to the beyond the time limit provided, but they took the credit. And the entire 62 crore which they have taken for construction material and services for constructing the commercial complex and on other ground has remained unutilized. This demand was raised. It has been challenged before the High Court. The issues which are before the High Court as of now are whether the restrict section 17(5)(d) is ultra virus whereby the credit is not allowed, whether the time limit of section 16.4 is applicable, whereby the demand ITC cannot be taken beyond a certain period, as provided, that is date of filing of annual return or date of filing of the return for the month of September of the next financial year, whether the time limit is applicable. Validity of rule 61.5, whereby 2B has been declared as a 3B has been declared as a return in lieu of 3, and also the gross interest on the gross amount under section 50. These are various challenges which have been raised in this Bagmane developers. High Court, by a very reasoned stay order, has granted interim relief, directed the party to keep only 10% of 62% in credit account unutilized. Remaining has been allowed to be utilized, and the matter is coming up for final hearing on 20 November after 10 days. And these 20, it may come up on the board, subject to availability, subject to the board, but at least Honorable High Court itself has picked the matter for the final hearing. It will be interesting to see, because there are multiple challenges. Like, it is my firm view that section 16.4 time limit it cannot apply. It is not at all operative, cannot be made operative in the present scheme of the provisions. Therefore, even for 17-18 and 18-19, it is permissible for the taxpayer to take the credit. Highly litigation prone views, I must say, but they are. In my opinion, today the time limit is not applicable. Similarly, 3B cannot be considered as a return, substantial return in place of 3 also. And therefore, that is another area of challenge. Not to speak about 36.4. 36.4 is definitely unconstitutional. So these are certain challenges. Okay. So this is the story. What is really baffling is, what is the logic and justification for denial of the credit on the construction of complex, in case of construction of complex where the units are actually leased out, on which 18% tax is being recovered by the government? I simply fail to see any logic or justification for this. Simply, even under the realm of the central excise, under moderate days also, there was a specific provision in the terms of Rule 57D, whereby it was provided by the legislature that no credit, moderate credit shall be varied or disallowed or denied merely because during the course of manufacture of the final product, a non-excisable or intermediate product comes into existence. So that is the basically the provision. It was never disallowed. Then why to stop the deny the credit on the ground that there is a immobile property which is coming into existence? That is something quite baffling. It is basically leading to unjustifiable cascading effect of the tax and also attendant distortions in the entire system. Therefore, this is something we may have to, the policymakers may have to seriously think of, instead of allowing the legal challenges to mushroom. This is not something which should be based on some personal factors. One has to take it, the overall economic and the philosophy behind the weight into mind. Next. Next. A is a leasehold plot with lease tenure of 99 years. Unexpired lease period is 70 years. Assignment of the leasehold rights by agreement for consideration in case and in kind of constructed area. Case consideration paid upfront and allotment of units on approval of the final plan. The two question, whether the leasing of the plot for the balance period of 70 years is liable to GST. This is a long-term lease beyond 30 years. There are two issues here. Whether this long-term lease beyond 30 years would be akin to sale or not, as per the Transfer of Property Act. And if it is sale, this issue is again a debatable issue. To some extent, it is right now involved into the BANM case, Builder Association of Navi Mumbai, where Bombay High Court held against the appellant petitioners and in favor of the revenue, where the the upfront payment or premium which was being charged by SIDCO for the allotment or the leasing of the land, leasing of the plots for residential construction purpose, which was being charged and on which service tax was being charged and GST is being charged. So that challenge, Bombay High Court ruled against the petitioners, Matter is right now in the Supreme Court. It is as of now listed on 22nd November, subject to whether it reaches the board or not. There are obviously advance authority ruling saying that long-term lease is liable to pay. They have relied upon BANM. However, recently there has been a challenge also in Rajasthan High Court. The problem is, if the lease on land above 30 years, no doubt now that has been exempted, but that is exempted only for the purpose of residential apartments. Notification 6/2019. The long-term lease of land, which has been actually exempted, is only if it is used for the residential apartment. If you very carefully see notification number 6/2019, these aspects should be kept in mind. And once for commercial apartment, also commercial complex, subject to exemption if any. The problem is that if the ITC is GST is paid, ITC is also not being allowed. So there is a cascading effect of tax. On this ground, a challenge has been raised before the Rajasthan High Court. Notification 6/2019, serial number 2 says, a promoter who receives long-term lease of land on or after 1st April 2019 for construction of residential apartment in a project against consideration payable. This is for residential apartment. Here, I would take a pause that there are two concepts, please bear it in mind, REP and RREP under the new dispensation. Residential estate project, real estate project and residential real estate project. RREP is been also defined where the commercial apartment area does not go beyond 15%, 15%. If it does not go beyond 15%, in that case, it is considered as a RREP. So those commercial unit also will attract the same rate of tax, 1% or 5%. Let us take it as a 5% only without getting into confusion. However, what happens if it is 15%? So if a long-term lease of land is actually obtained by the developer promoter, whereby either he is constructing the commercial apartment or where he is constructing the commercial apartment in a residential project which is beyond 15%, then in that case, the liability under reverse charge on the developer may arise in case of long-term lease which he has obtained. Similarly, even for the development rights or FSI, where the exemption is granted for residential and commercial apartment both, provided it is below the 15% in RREP. If it is gone beyond 15%, then proportionate reversal will be required. Proportionate tax liability will be required to be discharged by the developer on the land development rights, or subject to taxability. I'm not going into that. We have covered that. This is something, and he will not even be entitled for the ITC on that as per the present dispensation. This is again can be a subject matter of serious challenge on various grounds, as I have already explained. So the long-term lease, Greater Noida judgment is on a different footing, which has been actually relied upon by the Bombay High Court in Builder Association. Even that Allahabad High Court judgment has been stayed by the Supreme Court. So whether the reliance placed on Greater Noida was justified or not, this is another issue. There are multiple issues involved into this BANM case. And therefore, it is not possible to go into all the issues. What is government and authority, whether CIDCO is a local authority or not. There are many, many issues involved into this. Next. Yeah. So it is suffice to say, okay, as per section 105 of the Transfer of Property Act, and considering the stamp duty, which is paid as if there is a conveyance of the land itself, this long-term lease of the immobile property could be considered to be the violative of Articles 246, 246A and 265. I have already explained the implications of entries 18 and 49 and the pendency of the matter. We will also have to wait for Supreme Court judgment, a full bench judgment in mineral area development case. So much hinges upon this. And as I have explained, Greater Noida case is been probably erroneously relied upon by the Bombay High Court in BANM case. It is coming up, it is live as of now, the case is. Next. This is the sale of the developed plot. agricultural land and which is being developed into residential bungalow plot, and both are selling. The next place. There is a agricultural land owned by A. He enters into the JDA for development and land and dividing into the residential bungalow plots. No construction of bungalows, sale of the developed plots during the development, sharing in 50-50 ratio, unsold plots on the date of completion of layout to be divided equally, and project expected to be completed in April 23. Whether the sale of developed plots would attract the levy of GST. I am aware that there are not less than 5 advance authority rulings which have one way or another in the facts of the case have said that the plots developed and sold by the owner are liable to GST. I do not want to comment. I rarely comment on the advance authority ruling. I would only say that one has to be extremely careful and cautious while going for the advance authority ruling, considering the current constitution and the overall trend and the overall philosophy, the mindset by which advance authority ruling, unfortunately, are actually approaching the issue. This does not leave very much hope, and it leaves much to be desired. So therefore, please be careful before jumping to the advance authority ruling. I would go to the extent of saying that one has to go to the advance authority ruling only and only if there is no other alternative way, but not as a matter of routine. We are completely messing up the law because of the way the rulings are coming up. It is clearing the pitch even for the policy makers to really reframe the law and actually revamp the entire law because of majority of the judgment rulings which are delivered by the AAR. And it is the whole task is becoming Herculean in my humble opinion, or it will become Herculean because of this ruling. So one has to be very careful before going to the advance authority ruling at all. There is no, it should not be just simply rushed as a matter of routine. It has serious repercussions. Next slide. Having said that, whether the plot developed, sale of land is covered by entry 5 schedule 3. I will just explain my views. It is neither supply of goods nor supply of service. Sale of developed plot is where even if it is treated as a composite supply, I don't know why it should be treated as a composite supply also at all. But even if it is a composite supply, for the sake of argument, the predominant element is the supply of land and not the amenities which are created on the plot by the developer, seller. He is creating, he is putting up the rest of the facilities, but everything is done by him and it is being sold as a package, as a developed plot. These cannot be artificially vivisected and then say that there is an element of service also. That law originally laid down in Dialim case that an indivisible entire one contract cannot be artificially vivisected and part of it cannot be subjected to service tax, which led to the entry of the worst contract in 1/6/2007, as I explained yesterday, and the original judgment of Gannon Dunkerley that a composite supply of building or construction is a one entire indivisible contract. All these aspects, and I don't even consider sale of developed plot as a composite supply. This is only for the matter of argument. And therefore, it is as if the developed plot is a, it is ultimately a sale of land only. It cannot be considered that I am undertaking. It's a different matter that the ownership in the plot is first barren plot is simply sitter pass on to the buyer, and on behalf of the buyer or customer thereafter the developer or anybody else undertake any development activities, creation of the amenities. Then it is an independent arrangement and agreement. But whether I am selling the barren land or I am selling the developed plot, it is a sale of land only. And it cannot, I don't know, I mean, I am really, I find it very incomprehensible that how the sale of developed plot can be subjected to GST at all, just because some development activities. Applying the ratio of the Odisha High Court in Magus construction, this is basically, I am developing the plot for my own, because my sale agreement is for the developed plot with certain specific amenities. It can't be considered that I am undertaking the development activities or amenities on behalf of the buyer, I am liable. There is a condition for the contract and there is a consideration for the contract. These have been beautifully actually worked. This distinction has been worked out recently in the Remco Finance case by the larger bench of the tribunal. There are conditions of the contract and there is consideration for the contract. A condition for the contract cannot be actually equated with the consideration for the contract. So I am creating the amenities because it is a part of my condition of the contract. I am not creating that amenities per se on a standalone basis for the buyer. I am selling the developed lots with all these amenities. It cannot be liable to service tax. Very recently on 22nd October, surprisingly, in Abhishek Darak case, there has been a difference of opinion between two members of the advance authority ruling on the very issue. Member Sri Amit Gupta said that on a taxability of sale of developed lots, sale of developed lot does not constitute the supply of goods or service, not liable to tax. Next. Member Sri Anurag Mishra said, assurance to the purchaser as to the nature and extent of development that will be carried out as a part of the package, and therefore sale of land in entry 5 will include only undeveloped land and not the developed land. That is a very novel reasoning. The word has been used, a phrase has been inserted by Member Sri Anurag Mishra, reading in entry 5, that sale of land here means undeveloped land only and not the developed land. There is a standard, there is a golden principle of interpretation. If statutory provision has been read in its plain ordinary meaning, nothing should be subtracted, nothing should be added, nothing should be included, nothing should be excluded. This golden principle of interpretation, Hemraj Gordon Das, 1978 ELT Supreme Court, it means whether developed and undeveloped distinction could have been made by the learned member. In my humble opinion, no. But then matter has been referred to appellate authority because there is a difference of opinion. But my view is that developed lot cannot be subjected to levy of tax. Next. This is the last case study. Simpliciter, we are slightly pressed for time. I have to cover two more issues about the reversal of the credit. So these are the, basically there is a redevelopment of the society. This redevelopment society, which is basically the predominant activity in a city of Mumbai, whereby the society engages the developer to demolish the existing construction and construct the new building in which the members are allotted the new flats free of cost and subject to such other conditions. Corpus fund is also given by the developer. Accommodation allowance or shifting allowance is given. What other consideration, whatever other charges as agreed upon are given. In Maharashtra, a self-redevelopment is also being encouraged by the government. So either it can be self-development, which the society undertakes self-redevelopment by engaging a PMC, project management consultant for self-development, who will oversee the entire activities, or they directly enter into the developer. As far as if the roping in of the developer is concerned for redevelopment, society will grant whatever development rights or additional FSI available to them will be given to the developer as a part of consideration, which he will exploit for the construction of the sellable area on which he will be paying the GST, and members will be given the free of cost. It is in this context the liability has to be seen, whether society is a self-redevelopment or society engaging the developer for redevelopment, whether the liability arises or not. Next. 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 Society and member perspective, the issue. Next. I have outlined the issues also. First of all, society vis-a-vis independent buyer and society vis-a-vis member. This is under self-redevelopment. Under self-redevelopment, through the help of PMC, project management consultant, society demolishes the building and constructs the new building in which the original members are given the area as agreed upon as per the law. And whatever additional FSI which is exploited by the society, they are selling it to the independent buyers. So there are two recipients of the units in the self-redevelopment model, one original members, other independent buyers. Now let us see the taxability. Next. First of all, society vis-a-vis the member. I will be very short into this. It has been my consistent view that under GST also, the society mutuality of interest principle applies to society, members club, association. Also, even if the particular member or association might be otherwise engaged into some commercial activity. Therefore, a residential society or industrial society, residential society, residence welfare association are fully governed by the mutuality of interest principle, and a society cannot be said to be engaged into business. And therefore, the present dispensation of the law, whereby the exemption is granted up to maintenance charges of 7,500, and thereafter where the tax is payable, in my humble opinion, this exemption is of no relevance, because society cannot be said to be engaged into a business activity while maintaining the society in the name of the society. And secondly, the society and members are actually related to each other by the mutuality of interest principle. Kolkata Club Judgment Ratio clearly applies even under GST regime unless the law is amended. And therefore, even after GST advent, a society or members club, etc., are not liable, cannot be held to be liable on the principle of mutuality of interest, apart from the fact that a society, normal circumstances, society cannot be said to be, because hardly a society would be engaged into a business activity. And therefore, I hold the same view for the religious trust. I hold the same view for the education trust also. Kolkata Club Ratio fully applies. As a matter of fact, I understand that GST Council has also taken note of the Kolkata Club judgment, and they have, in principle, they have agreed that after Kolkata Club judgment, the ratio applies, and in the current dispensation of the statutory scheme of the things, the levy of GST would be will not get attracted even on the members club or like that, which will apply to society also, unless we amend the law. I will not be surprised if in the coming days, next year or thereafter, there could be a retrospective amendment to host of the provisions, business, supply, etc., whereby the levy on the society and members club and other such body of person is regularized. As of now, the statutory provisions do not permit the levy. Therefore, when the society undertakes the redevelopment and allows the unit, constructed unit, to the original members, there is no question of liability of GST. Next. Yes, I have covered this. Next. Coming to the member, sorry, limited. GST liability, previous slide, please. GST liability of members. Now, society is also giving some accommodation allowance and shifting allowance to the member for shifting when the building is being demolished, just like the developer. This will apply both in case of developer if he is roped in for redevelopment, and this will apply even if the society is undertaking self-redevelopment. So I do not have to repeat. When a member receives any fund or any amount in any form, shifting allowance, accommodation allowance, some corpus, or whatever charge is, even broker for finding out a new place, temporary new place, brokerage service, in all these cases, the member cannot be said to be engaged into the business vis-a-vis the society or vis-a-vis the developer. It cannot be said, and therefore there is no question of any liability arises. In Zaver Shankar Bhanusali case, advance authority ruling before amendment to section 7 had held that when the tenancy rights are actually surrendered because the landlord is actually redeveloping the building for which the consideration is given to the original tenant, it is liable to GST by relying upon the entry 5 of the schedule 2 and tolerate an act or situation. He is tolerating the hardship of moving at some other place for which he is getting the consideration while surrendering the tenancy right. Based on this, the advance authority ruling said this is liable to GST. It was absolutely an erroneous ruling, because even without amendment, as I said, Schedule 2 was never intended to be, was never operative as a deeming fiction. So merely mention of tolerating a situation or act or obligation to do an act could not have been relied upon as a casting as a supply. It cannot be treated as a supply. This has been made clear after the retrospective amendment and insertion of clause 1A in section 7, that if a transaction or activity is a supply, then only the question arises about the leviability. Now, when I am shifting to other place for which I am getting some accommodation allowances and other charges, I cannot be said to be engaged into any supply, much less the business. It is not a business activity. This transaction goes out of the levy of the tax, whether the developer is involved or whether the society is involved as a redevelopment. Next. Then for GST levy on extra area purchased by the member, again, the same concept should apply, in my opinion, because there is no mutuality principle as far as the society is as a redeveloper is concerned. And however, for the independent buyer, the GST basically is could be an issue. Very interestingly, under self-redevelopment product, as per the scheme, an independent buyer also cannot buy the flat directly without first becoming the member in the society. When he becomes the member of the society and then buys the flat, which is really developed by the society itself, then again the mutuality of principle can, mutuality of interest principle can come into play, and therefore the leviability can be under challenge. These are whole untested propositions, but worth proposition. I'm very clear in my mind. Mutuality of interest principle holds good for society, members club, etc., irrespective of the definition, because the requirement of profit motive, etc., which has been done away in the first 3 clause of the business definition, these profit motive, regularity or frequency are very much essential for the entry relating to the association or body of person or society. There it has not been done away with. And mutuality of interest, because there is 2 distinct persons are required before the levy is attracted. In case of society or members club, the distinct persons are not existent and there is no deeming fiction. Therefore, no levy. I'm very clear. This can apply even for the independent buyers who is buying the flat in the redeveloped society, with the society has redeveloped, because he first has to become the member and then he is becoming like any other member. Litigation prone, but yes. Coming to the GST flat sold after OC, I'll take it as an independent proposition. This is my last, that was the last issue which I would be taking up. So whether self-redevelopment, society reselling any flat, selling to independent buyer, assuming taxability, if any flats are sold by the society after OC is received, or where the developer is selling any flat after OC is received, in these type of cases also, whether the ITC reversal, if it is availed, is required or not. I'll deal with them separately. Next. RPG, I will take another 5 to 7 minutes on here, just to complete all this. From the builder society, members' liability to GST on the amount received from the builder, as I said, member cannot be said to be engaged into the business. Entry 5, obligation to do an act cannot arise, cannot apply. Therefore, members are not liable. Then, sorry. Levy of GST on the grant of FSI by the society. I have already explained that development rights or FSI or transferable development rights cannot be subjected to tax at all because they are covered by the development immobile property, because they are the benefit arising out of the land. Same logic will apply here. GST liability of ITC reversal in respect of the flats sold post-CC or flats allotted free of cost to the members. In all these cases, I'll take up the different separate slide. And next. Okay, this was the last slide. Please come to before case study, can you just come quickly? Before my discussion started on case study, yes. Yes, yes.
Yes sir.
RPG case study 1 के पहले का जो case study है ना वो लेना है.
हाँ सर मैं वो कर रहा हूँ सर. Case study 1 के पहले. इसके पहले सर
इसके पहले
दिस इसके पहले दिस वन सर
या दिस वन इसके पहले एक बार एक देख लेते हैं, शायद वो उसके कनेक्शन में नहीं है ना। यस पहले
sure.
हाँ एक और एक जरा देख लीजिए स्लाइड। Yes. I'll now take up on the two major issues: valuation related issue and the reversal of CENVAT credit or ITC related issue. PART-2A was inserted from 1/4/2019. Now, the valuation provision have been roped in through notification 3/2019 up to 8/2019 at different places for a couple of purposes. One, if the landowner is receiving the constructed area from the developer to whom he is giving certain development rights. So whether developer promoter constructed area where the consideration is in kind to the original. I'm not now talking about taxability. We have covered taxability in detail. Now I'm assuming the taxability. The valuation which is deemed to be provided is construction deemed to be equal to the total amount charged for similar apartment in the project from the independent buyer other than landowner, and nearest to the date on which DR development right or FSI is transferred to the promoter. Please understand, today, let us assume, forget about my case study number 1. Today, I have as a landowner transferred development rights in 40% of the land I am owning to the developer. In consideration of that, I am actually, he is giving me some constructed area. Project is undertaken. Transfer of development right in favor of the landowner has taken place today. After 3 years, suppose the constructed area is allotted to me because the project is actually taking the shape after 3 years. He is giving me constructed area, and I am actually, am I supposed to value the development rights at the flat sold by the developer after 3 years to an independent buyer and apply it to the DR development right which today, before 3 years, the landowner is given to the developer? I mean, it is absolutely a illogical, improbable proposition. The deferment of the tax liability when the possession or allotment is given cannot really hide the fact that there is no valuation mechanism. After 3 years, 4 years, can this, and this is development rights in respect of where the units are sold post CC. When the post completion certificate, if somebody is selling the unit for proportionate development right, which the land developer has obtained from the landowner, he is required to pay service tax under reverse charge. First, the assumption is that development right is or TDR is liable to tax. Taxability has been assumed, which itself is wrong. Because taxability is assumed, therefore exemption is being given so that the people do not raise the hue and cry. Then it has been shifted to reverse charge under promoter, because obviously landowner will be an individual person. He might be some uneducated person owning a piece of land also. So very quietly, the liability has been shifted to the promoter. Even if granted all these things, how can a valuation be adopted of the similar flats sold to the independent buyer to value the development, proportionate development rights? The whole proposition is illogical and illegal in my humble view. Next. Next. And this entire landowner share, the valuation related provision is philosophy is directly from the circular, erstwhile circular February 2012. And section 15, if you read, in my opinion, this entire PART-2 and valuation mechanism is ultra virus section 15. And besides, excessive delegation, subordinate legislation cannot really prescribe a mode of valuation which is directly in teeth of section 15. An impossibility of obtaining value of similar apartments sold to independent buyers when such sale takes place much later. That's what I explained. there is a established principle of law. Law does not compel a man to do that which he cannot possibly do. In case of landowner share of constructed area, indirect inclusion. Now there is another proposition. The landowner is giving the development rights. These development rights in the first instance is exempted, provided all the residential or commercial apartment in the project are sold before CC. Post CC, if anything is sold, then promoter developer is liable to pay the tax proportionately on development rights under reverse charge. When he does that, he has to apply the value of the similar apartment sold to the independent buyers. In case of independent buyers to whom it is sold, right? Now I am talking about the landowner getting the constructed area from the developer, not on the development rights. Development rights we have covered. That is impossible to apply that value. Come to constructed area. The developer is giving constructed area to the landowner. How does he value it? At the similar apartment sold to the independent buyer. Similar apartment sold to the independent buyer, there is a transfer of undivided share of land also. Because undivided share of land is getting transferred in favor of the independent buyer, for which only 1/3 value towards the land is being allowed as a deduction, will it not be the case where part of the land value is also built in the value charged by the developer to the independent buyer, and which gets percolated and gets imposed on the landowner also, to whom only constructed area is given without any other consideration? Is it permissible in law? Because similar apartment, there is a transfer of undivided share in land. And therefore, the whole proposition is subject to susceptible to challenge. Obviously, there are a lot of other aspects, but it is not possible to go into too much of nitty-gritty. I am laying down the broad proposition only, which only I can do today. Next. Coming to the reversal part. The reversal part has 2-3 issues. Before 1/4/2019, even during service tax regime, and even after 1/7/2017 up to 31st March 19, in case of developer builder, whether he is obtaining development rights or whether he is undertaking the construction on his own plot, any unit sold after CC or OC, the ITC or CENVAT credit was sought to be reversed. That was the country, and there were huge demands which are pending across the country or raised across the country. This reversal was never mandated by the law. As laid down by Eicher Motors and IEG, once the credit is availed as per law, my entitlement to the right to input tax credit or CENVAT credit, I have to determine on the basis of the provisions of law on the date of taking the credit. Once I have complied with the law and my availment of the credit is within the 4 corners of law, that right becomes indefeasible. It is not a concession. It is a right, and at least under GST, I would call it even the constitutional right. Even if some doubt remains that it might be a concession or benefit in the earlier dispensation, in my humble opinion, under GST, it can be said that ITC is a constitutional right. That being the case, or flowing from the constitution, or to put it other way around, if that be the case, then once it is availed as per law, that credit remains indefeasible permanently. It cannot be taken away or varied or defeated by the legislature in any manner. That is the ratio of the Supreme Court judgment in Eicher Motor and Daiichi. And therefore, whether reversal can be mandated at all, and on what ground the reversal will be called for. Can it be said that I have availed the credit wrongly? Because on the date of taking the credit, I had no idea, or I have no inclination, or I did not know how many units I will be selling after completion certificate. I am undertaking continuous activity of construction and selling the unit under construction. Part are sold after completion certificate for whatsoever reason. Can it be said, therefore, my original availment of ITC or CENVAT credit was wrong? Credit can be recovered even under Rule 14 of the CENVAT credit rule and under Section 7374 of the CGST Act, only if it is wrongly availed or utilized. Can it be said I have wrongly availed or utilized the credit? Because everything I am doing during the concurrent period, during the relevant period as per the law. Where is the mechanism for the reversal? This reversal is not provided even, and whether any such new mechanism, is it not fall contrary to the section 73 and 74. This proposition has been laid down by Gujarat High Court in LMB case, followed in TPL case by Bangalore Tribunal, and by other coordinate bench in the Prajapita Builders case, whereby they said, in the absence of any statutory provision, the liability, the reversal of CENVAT credit for the units which are sold post-completion certificate cannot be imposed on the builder developer, firmly laid down by this law. It was only on 1/4/2016, an explanation was inserted in Rule 6 of CENVAT credit rule that for the proportionate CENVAT credit purpose, even any activity which is not a service should also be taken into account. I have serious reservations about the explanation validity also. I feel it is gone beyond the scope of the fundamental provision and it is ultra virus. But that is something. But at least till 1/4/2016, these judgments have very clearly held that no liability arises for the reversal of the CENVAT credit when the in case of the units which are sold post completion certificate. There is no similar provision existing in case of CGST, which would directly support the proposition that after completion certificate, if the units are sold, the credit has to be reversed, irrespective of 17(3). As I said, after completion certificate, sale of unit sold is a sale of immobile property. Immobile property is per se outside the purview of the levy itself. If something is outside the purview of levy, can it be brought within the scope of proportionate reversal provision? There appears to be a conflict between exempted supply definition, section 17(3) and schedule 3. So when there is a conflict between the two substantial provision of the CGST Act, not conflict between the Act and the rules, conflict between the two substantial provision of law, which would prevail, or whether a substantial provision can go beyond the constitutional mandate. These are certain questions which would arise, because there is otherwise no specific provision related on the line of explanation 3, which was inserted in Rule 6 under CGST Act. And Rule 42-43 mechanism cannot validate the reversal of the credit. Next. Sorry, please go back. There is a slide previously, but I will not waste time in searching for that. I will just complete in the same brief. Similarly, in case of ongoing project, when on 1/4/2019, a developer builder actually goes for the new scheme for any reason, it is provided that the credit which he has availed till 31st March 2019, he will be required to proportionately work out that credit in respect of the construction activity undertaken by him after 1/4/2019 in an ongoing project on which he will be paying the tax at the 1% or 5%. And that proportionate credit should be reversed by him. Second, if he has availed the less credit, he should be entitled for the refund also. Or that is what the proposition. I think the refund part is basically just to cool the mind. It is not one-sided. It does not make any difference in my opinion. Whether from 1/7/2017 from up to 31st March 2019, a developer builder having undertaken a project availing the ITC, who then shifts to the new tax dispensation, can he be asked to reverse the credit for the past period proportionately, depending upon the constructed area he will be selling at the concessional rate or after CC after 1st April? In my humble opinion, the answer is in negative. There is no provision in law which would substantiate or justify or which would validate such type of reversal mandated by the notification. Notification is a subordinate legislation. And one important point here is notification 3/2019 is basically a rate notification whereby the concessional rate of tax is provided to the real estate sector subject to certain conditions. It does not come within the purview of the exempted supply definition at all. Exempted supply definition, as I pointed out earlier, is defined to mean a supply of goods or services or both which is wholly exempt under a notification or chargeable to nil rate of tax, or on which no tax is leviable, or which is and includes non-taxable supply. So nil rated tax supply, then nil rated supply, wholly exempt supply, and non-taxable supply are covered within the scope of exempt supply. Notification 3/2019 is not wholly exempting the supply of the for the real estate sector under construction unit. It is providing the concessional rate of supply subject to non-availment of ITC. Once it does not come under the exempted supply scope at all, 3/2019, how can it come under the scope of section 17.3 at all? Because section 17.3 speaks about the proportionate reversal of credit between exempt supply and taxable supply. Notification, exempt supply does not include the notification 3/, therefore no reversal is required at all. This sums up my entire discussion. Please only take the last slide.
Take the last slide.
Last slide, just before my thanks. Last slide. All case, after case studies, 192 or 191, whichever is. Yes, and fine, with this, you can imagine how complex the things can become for the real estate sector. There is a lot of derailment of the policy initiative. The non-grant of the ITC or taking away the benefit of the ITC is basically a cost for the developer builder, only which sooner or later the customer will be bearing indirectly, directly they might be bearing now. I hope there will be an immediate course correction in this, because real estate sector cannot be kept out of the ITC chain in this manner, because down the line it will create, and it is already creating lot of distortions and lot of malpractices. I'm afraid to say so. I'm connected with this sector and the ferrous metal industry, CTD bar, TMT bar, plate, channel, etc., cement, and all for more than 3 decades. I know there are a lot of constraints and lot of practices which are going on. Why to indirectly encourage the bad practices? I'm sorry to say this. So I hope the policy makers will give a very serious look to this entire imbroglio, and they will revert back to a pragmatic and prudent policy much earlier than it is. We have lost so much in last 1 year because of this ill-founded policy, in my opinion. Having said that, because of the complexities of the issues involved, and every agreement, it can't be copy-paste. The terms cannot be copy-paste. One would learn at his own cost. One has to be extremely clear and careful while drafting the commercial agreement. I sincerely enjoin upon everybody, whether real estate sector or any sector, professionals and the taxpayer will have to be very careful now about the commercial vetting of the drafting. GST is only one part of it, but still it has to be taken into account, and one size fit all type copy-paste terms and condition is not advisable, because at the end of the day, the court judgments will depend upon the facts as narrated in the agreement and what the intention of the parties are. So it is extremely important, because this aspect has been given a go by, particularly in the Google, there is a copy-paste structure. So ready-made agreement cannot be an answer to your ills. One has to be very careful. So all aspects should be taken into account: IT, income tax, then GST, and all other commercial terms, and both parties should be very clear, whether it is an arbitration related issue or IBC or whatever, ultimately the agreement will prevail. Please understand. So the intention and the tax ramifications should be very carefully thought out and should be very carefully outlined in the agreement. That is my suggestion. Thanks for very patient hearing. There is much to be said on all this real estate sector. I have tried to cover as much broad issues and as practical all issues which are the current issues. And I once again thanks GST Corner for this wonderful, this very, very godsend opportunity given to me to really fine tune for learning. It is a learning process for me during all these days when I was working on this complete thing. I will fine tune this entire presentation and send it in as early as possible, so which you can actually circulate among the client. Recording, we will take care of that recording also, but at least the presentation I will share. On the litigation prone area, I will only just tell one thing. Those parties, those taxpayers who have not undertaken the reversal after 1/4/2019 for ongoing project, there is a time still to pay it through the DRC 03. So without going into the taxability, I have explained that everything. But if anyone wishes to, there's still the time left for do the reversal to the DRC 03, which they can go for it just to avoid any other litigation. Otherwise, all the entire structure and various issues are definitely prone to litigation. Thank you and good luck.
So now we can deal with the query in the chat box.
Please. Yes.
Sure. So we have put it in the chat box.
Yes. I am real estate developer. I have sold land only which is not subject to GST. My land is on hilly area. As per sale of agreement of land, landowner has to level the land. So I have to do land leveling work. My question whether I can utilize land leveling input tax credit to my other commercial project GST liability. Because the sale of the land, or in your case, assuming it is a developed land which you will be selling, it is outside the purview of the tax. And the land leveling for which you are availing the services from other contractors is exclusively related to that leveling of the land which you are ultimately selling. There is a connect between the two. The credit cannot be availed, nor can it be utilized for other taxable activity.
Next.
I can see only this man. Yes.
Yes.
Developer, when he charges landowner for construction of apartment, whether he has to charge 5% or 18%. As I said, the notification and the scheme of the new taxation scheme after 1/4/2019 says 5%, assuming it is a non-affordable residential unit. In my opinion, it can be 18% under the residual entry 12 of serial number 3 of notification, whereby complete ITC would be available and the deduction of the value of the land fully can be claimed. This is a debatable issue, but this is my legal view, my personal view, that otherwise it is 5%. And for landowner also, assuming the taxability, 18% is definitely residual entry is a separate. Within the scheme of the thing, it will be only 5% to the landowner also. It can't be, it is not 18%. I'm sorry, vis-a-vis landowner also from who he might have obtained the development rights, it will be like any other tax rate, 5% only. And even if the landowner sells that under constructed unit, if you accept the taxability, it will also be 5% only, but not lesser than the price at which he has sold, because he will be entitled for the credit only what has been charged to him by the developer. As far as I understand, transfer of development right is transfer of immovable property. Is this statement supported by any case law? If so, could mention the case law then. I have actually mentioned a number of case laws during my deliberation. So there are, it is very, I think I made this very clear. Can you throw some light on taxability of forfeiture of advance money in case of sale of immovable property? When we talk about sale of immovable property, there is no question of the taxability, and therefore any advance money which is forfeited, if the basic transaction is not liable to tax, any advance money which is forfeited in respect of that basic transaction of which is non-taxable cannot be subjected to tax. If advance money, suppose I am selling the land and I have received some advance money. Now the buyer fails on the commitment and I forfeits the advance money. Sale of land is not liable to tax. So that advance money cannot be treated as a separate independent supply. Schedule 2 will not come into play, and therefore there is no question of liability on the advance money retained by me as a seller of the land.
Next.
Builders WIP, transitional credit issue for work in progress. Department is asking for reversal of ITC. I can only say this is a very, very highly debated issue. There are income tax status will also come into play, because in the builder balance sheet, typically, this is all the unsold flat are shown as a inventory. And if you very carefully see, subsection 3 of section 142 or 140 of the CGST Act, if I am not mistaken, then the language actually could create some problem. It is a matter of interpretation. My view is this is a debatable issue. I cannot, it would be very difficult for me to go into detail. We have already passed time also. I can only say that there is a case to argue that any input contained in such type of unsold inventory of the flat would come within the scope of work in process, and therefore transitional credit would be available. If the department raises any query, any demand, I would only say that that is my always a clear view that no demand simpliciter by letter can validate can force the party to pay the demand. There has to be a process of law. Section 73 will have to be followed. I don't know why section 74 has been invoked everywhere. It is for evasion of cases. But normal period is not expired under section 73. Where is the question of evasion? So section 73 time limit will come into play. So cause notice should be insisted upon. There is no compulsion. There cannot be any compulsion on any taxpayer to make good any amount just because the department is asking by a letter. That's all. So ask for the so cause notice and one has to fight it out. Kindly clarify the conflict of existing provision of Article 366(29)A, which deems that works contract can be vivisected and goods can be taxed by state as sale of goods, and deeming the works contract as service under. I have already covered up this. I don't want to go too much detail into this. I feel that Article 366(29)A, not only it has been retained because the weight assessment across the country are pending, and weight authorities, state weight authorities could not continue with probably the assessment of the weight liability on the works contract unless and until the mother source in the form of Article 366(29)A is relevant, is available. The moment you omit the Article 29A, clause 29A, the whole weight assessment may probably become nullified on the works contract. This could be one of the reasons. Having said that, I think pragmatically, world over, the construction, real estate related construction contract or building contract are declared as supply of service. World over, they are treated as supply of service only under the weight jurisdiction. I personally, philosophically, theoretically, principally do not find anything objectionable to call works contract as a composite supply, as a supply of service. It is a prudent and pragmatic thing to do. However, there is a clear conflict between Article 366(29)A. So if the conflict arises, obviously constitution will prevail, and then the fate of entry 6A may hang in balance, because in any case schedule 2 is not a chargeable provision, it is only a categorization provision. So if the conflict arises, constitution should prevail. We as a partnership firm having 4 partners, we have taken land on development before GST era, that is in service tax era. Now we are giving flat to landowner, and also we are registering flat in the name of partner. Whether GST is required to be paid on flat given to landowner and also flat taken by partners themselves. I have covered this in detail. In my opinion, this is a debatable issue as far as the constructed area given to the landowner, and in this particular case partner also. Because if I go by CHEDA Development Corporation, Bombay High Court, the development right, transfer of development right is a consideration. So the consideration in kind is already received by the builder, developer, in the form of development right. That be the so, the supply from the developer is the constructed flat given to the landowner and partner. At least from the partner, there is no consideration. I need to have the all other details also. Assuming this so, the question arises about the valuation. If the taxability is accepted, because one cannot deny, going by the Bombay High Court judgment, that development right transfer is a consideration. It may not be, it is not a taxable supply, but it is a consideration. But then the question of valuation arises, and on valuation, I am very firm in my opinion that the valuation mechanism fails as far as the allotment of the free of cost constructed area to the landowner, or in given case partner, is concerned. It is a highly litigation prone issue, but I mean, that is what the law is. How to value flat given to landowner and flat taken by partner and the rate applicable. As I said, in case of landowner and partner also, valuation mechanism fails because Rule 27, from partner, obviously there cannot be any consideration. So simpliciter free of cost, whether it will entail the liability, and suppose it is before 1/4/2019, any credit is taken, whether credit is required to be reversed. In that case, in the same line, let me also clarify one point. I might not have said this, that in case of society redevelopment also, or developer also, one argument is possible for the redevelopment, and that is whatever free of cost is given to the existing members or under SRA or MADA scheme to the existing occupant or tenant, the sellable area which is sold by the developer builder on which he is paying service tax or GST, the cost of that construction is already included into the sellable area on which he is paying service tax or GST. So Vasanta Green ratio will apply. No doubt it is in the Supreme Court. But onus will lie on the builder developer to establish that the cost of construction of free of cost unit given to the existing members or the tenant is already included by him in the cost of construction of the sellable area on which he has paid the service tax and GST. That onus will lie on him only. And on the valuation front, assuming that valuation is to be done, in my humble opinion, it can't be equivalent to the amount charged, price charged to the independent buyer. It can only be the cost construction method. It cannot be the value charge, the what price has been charged to the independent buyer at the nearest point of time. Regarding GST payment on RCM basis by developer on development right, developer has to pay GST and proportionate value of development right as relatable to the unbooked area of project as on date of OC. Whether unbooked area in this regard is including landowner share or excluding the landowner share. Assuming the taxability of this entire proposition of reversal of ITC, it would also include the landowner share as well. Since supply of land is exempted, as per composite supply, there should two or more taxable supply naturally bundled. Hence, it can be not be composite. Am I right, sir? Obviously, that's why I said, okay, sale of developed plot is also not a composite supply. Even though part of it is composite, made up of the development of the amenities, which can be treated as a service. But other is a land only. Where are goods involved into this? So therefore, there is no taxable supply of goods or services, and therefore developed plot also cannot be treated as a composite supply. Sir, when sale of land or completed construction unit considered to be neither a supply nor supply, then why it should be considered for reversal? I would dealt with in detail, so there is no need to go into this question. I understand. Daily wages labor also to be considered for the purpose of shortfall of 80%. Here, I would not like to much get into this. There are many services like maybe the Plant Development Authority, UDA, Haryana Urban Development Corporation, or Delhi Development Board, etc., to which where the liability arises of GST, and these are not covered within the scope of 80%. So there are many issues. So in nitty-gritty, it would be difficult for me to get into this. Whether the labor and wages, personally, I am feeling that wages and labor will not come within the purpose of, for the purpose of 80%. Next. Other charges collected by builder, including 1 year advance maintenance, club membership fee, legal charges, etc., is subject to GST. If yes, then at what rate? On the maintenance, I will only say this, that from the society or builder, when the builder is undertaking the building project, whether it is a redevelopment or an independent project of him, he collects, like under MOFA, Maharashtra Ownership of Flat Act, he is required to maintain the property, the entire project till the society is formed. So generally the builder developer collects the maintenance charges in advance for a couple of years from all the buyers. In advance he collects, or periodically. And on the first, when the society is formed, thereafter to the residential cooperative society in the first AGM, builder gives the account of that maintenance charges where he has spent, because he is required to maintain this as a separate escrow account. Okay, because he has to take care of the project as per the RERA regulation also, and MOFA also. This has been held to be not liable to service tax in the service tax era under the Ajay Kumar Baheti case. Bombay Tribunal has held, approved by the Bombay High Court also. It has been followed in another case by the tribunal also, Ajay Kumar Baheti, BAHETI, and this case has been followed by other tribunal also. In my opinion, the ratio of this judgment applies fully even under GST. Therefore, maintenance charges collected by the builder in terms of MOFA as required by the RERA for maintenance of the project till the society is formed cannot be subjected to liability of tax at all. Then, Is there any specific yardstick for limitation measurement irrespective of land to consider for levy of GST for the construction of residential flat in the land of less than 1 ground in JDA by landowner 60% builder 40? If so, whether, so this is the question which would be difficult to deal with, because first the facts are not sufficient and we may have to take into account a lot of ground level realities including RERA. So I would be constrained to skip this question. Next. Subleasing of land which belongs to GIDC is a taxable factory said with lead. This subleasing is right now under the matter of debate. Lot of transactions are taking place in MIDC. Simpliciter subleasing may come within the tax liability. But if that leasing is, suppose there is a 99 years lease or 70-year lease on which the plot is taken from such industrial bodies, MIDC or JIDC, and then only 10 years the original lessee has used the entire plot. He has constructed the structure also. Now he is actually letting go this structure by selling, loosely speaking, selling to another. He might enter into one single contract. He might enter into two independent contracts. Sale of land which has been leased out by the say MIDC or GIDC to him, and the structure also, both separate a contract. Whatever may be the commercial arrangement for the remaining period of say 50 years. Originally it was for say 60 years. So this is a long-term lease. This will be a lease arrangement. And this where the MIDC will act as an approved party. They will act as a confirming party. And the next buyer will come as a lessee in the books of the account of MIDC or GIDC. This whole issue right now is mired into litigation. And we may have to wait, but except litigation, there is no simpliciter subleasing. One can say that the credit GST is payable, and the other party, if he is a manufacturer of the goods or taxable supply, he can avail the credit. That is my view. Because safari retreat ratio, while we are on this, let me say my personal view is this: safari retreat ratio will apply even to a person setting up the new factory, and where he is going to manufacture and the goods on which he would be paying the GST. So just like service of leasing the commercial units, even the factory, subject to other constraint and condition laid down under section 17(5), plant and machinery, capitalization, all this civil construction credit is not allowed. Subject to that condition and constraint, a person setting up, a taxpayer setting up a new factory, suppose, under and for which he will be making the taxable supply of the goods, is entitled for the credit based on the safari retreat on the construction material and services. Is there any, does the landowner get ITC of GST charged by developer on the flat allotted to him for utilization in further sale of flat by landowner under 5% scheme? That is honor. Assuming the taxability of the landowner, as I explained, he is entitled for the credit of whatever credit of the tax which has been charged to him by the landowner, but provided his output tax liability cannot be lesser than the credit which he would be taking of the ITC charged to him by the developer. When the landowner is selling his area of constructed unit on which he would be paying the tax at 5%, but his 5% liability should not be less than the credit which he would be availing of the tax charged to him by the developer. Next. Next. Yes, he is getting the credit. Next. How can I allocate input tax credit to pay 18% when I am paying GST at 5% without input tax credit for residential flat sold? There is no question of allocation here. Either one goes for the 18% residual entry if somebody is bold and adventurous, but legally I think that option is available. Take full credit. The buyer may not like to pay 18%. It is possible to charge buyer 5%, suppose. It is a commercial arrangement, and pay the tax at the 18% to the government and take the full credit, and also claim the deduction of the land. That is my view. Because any excess of the value of the land beyond 1/3, even in the normal circumstances, is an indirect tax levied on the immobile property called land. And therefore, if I have cleared this part, so as I say, in the residual entry, one can do this. Buyer can be, your commercial arrangement with buyer can be something different. Your legal arrangement with can be something different. Other charges collected by builder, legal charges, etc., is subject to GST at what rate? 5% or without? Other charges will depend upon for what purpose it is being charged. If it is a part of the agreement, reimbursement, it is very difficult to give a conclusive answer on this. This will depend upon the agreement entered into by the builder with the buyer. Any more question by the partners? Please say. Okay.
So one last question, sir.
Yes. JDA can develop a value construction service provided to landowner based on construction cost plus 10% and charges GST at 7.5% without ITC, or 18% with ITC is compulsory. You see, under the JDA, if I have understood the question correctly, the developer value construction service provided to landowner based on construction cost plus 10% and charges GST at 7.5% is the tariff rate. After 1/3, the deduction one has to see that also. But assuming here there is nothing like 7.5% rate, ultimately it will boil down to 5%. The question is that for the landowner area, the issue boils down to assuming the taxability, assuming the valuation is permissible, whether the valuation is based on the similar flat sold to the independent buyer or whether it should be on the cost construction method. If it is on the cost, in my view, it is a cost construction method. It can't be independently sold to the buyer, and the rate of tax will be 5%. Reference to 18% with ITC is only as for the project as a whole under the residual entry. It is simple. It is different. It is entirely different. What treatment should be given in return for flat sold after OC? Nil, exempt, or non-GST? If there is a non-GST, then I mean, I'm not happy with the non-taxable supply. That is the nearest I will come to. It is not nil. It is not exempt. Non-taxable supply is basically defined as a supply of goods or services or both on which no tax is leviable. That is how it has been defined. Sale of constructed unit after CC is neither the sale of goods or services. It is a sale of building or part thereof. It is a sale of immovable property. So therefore, calling it as a non-taxable supply does not arise because it is not a supply at all in the first place, irrespective of its placement under the Schedule 3. So you can probably put it under non-GST supply, but by asterisk and put a remark or by a separate letter, put your claim that only because of the non-availability of a proper column, the sale of constructed unit after CC is being put under non-GST, but otherwise, in our humble opinion, the such supply of the constructed unit after CC does not come within the purview of the non-taxable supply because it is outside the purview of GST. A separate remark can be put just to keep your claim alive in a different. Because in my opinion, even the provision of reversal is also is without authority of law. But as a precaution, you can put it under non-GST with a rider.
So the questions has been over yet.
Okay, thank you very much.
I thank on behalf of all participants who have joined who make this. I deeply thank Mr. Shailesh sir, who has taken utmost care to cover each and every topic from pin to plan of the real estate sector and the issues which are facing right now, the industry is facing right now. I thank on the behalf of GST Corner to Mr. Shailesh sir for giving this contribution towards the professional enhancement. Thank you so much, sir.
Thank you. Thank you very much. Thank you.
We may end
it's a pleasure.
Session.
Good luck and all the best.
Yes. Sure. Thank you so much, sir.
Thank you, sir.